before we begin the County Housing Authority Fair Housing Month presentation by Attorney Maya Zebel, I'm going to go over a few things that Prairie State Legal does as far as our generalized special services. This is just a legal disclaimer that the things that we talk about, if you do have questions in the chat, we can't go into details, but we can give you general information. We're going to cover today who is PSLS, what can PSLS help with, how to apply, special project, resources, and any questions that you may have. Our mission at Prairie State Legal Services is to ensure equal access to justice and fair treatment under the law by providing legal advice and representation, advocacy, education, and outreach to serve and promote basic human needs and enforce and uphold rights. Who is PSLS? Prairie State Legal Services offers free legal services to low-income individuals and those over 60 with serious civil legal problems and need help to get them solved. Legal help is available also in any language when you come to Prairie State Legal Services. We get free legal services. And free, that means there's no fees associated with it unless it's something that's out of our control. PSLS is able to provide free legal aid because of the support from individuals, businesses, and different grants that we have obtained. We want to help you, but you must meet the eligibility guidelines, which includes financial criteria. Where is PSLS? PSLS has 11 offices throughout northern and central Illinois to serve in 36 counties. All of our offices are accessible to people with disabilities. Our walk-in offices specialize in servicing those in Lake County, Illinois. Our office is located at 325 West Washington Street, Suite 100. You can also be contacted by phone by contacting us at 847-662-6925. So, I know you have a question. What can PSLS help with? We help with keeping people safe, housing, and financial stability. We help with domestic violence, order protections, divorces, and housing problems. We also can assist those with Medicare, Medicaid, and other healthcare issues. We look at elder abuse and financial exploitation. We can also look at the loss or denial of public benefits, such as SSI, SNAP, TANF, and veteran benefits, Medicaid, and housing vouchers. We specialize in evictions, landlord lockouts, and housing policy issues, utility disconnections or denials, consumer debt and collection issues, where income or assets is at risk of garnishments, and we also work with sealing and expungement of criminal crimes or criminal records. What can't PSLS help with? We can't help with cases that generate fees. We cannot help with criminal and traffic cases. We do not help with euthanasia or assisted suicide. We also cannot participate in organizing, lobbying, or any demonstration. Representation of undocumented clients, except in domestic violence-related matters and human trafficking matters, and cases where there is a conflict of interest. Who can PSLS help? Adults over 60, persons with disabilities, domestic violence survivors, individuals with limited income, and veterans. You must be a U.S. citizen unless there is an act of domestic violence or human trafficking. Income eligibility and fees. Our legal services are provided at no cost to our clients. Some clients may encounter third-party expense that's related to the charge by non-PSLS entities, of which we have no control. Income eligibility depends on the type of case and funding available, and we encourage everyone to apply. Seniors over 60, there is no income eligibility, and for survivors of domestic violence, there's also no income eligibility. How to apply for our services? You can call the office number directly. You can also go online to illinoislegalaid.org or pslegal.org to get started. We also offer walk-ins every Wednesday at Prairie State Legal Services. And at those walk-ins, again, we can help with housing evictions, unsafe conditions, discrimination, public benefits again, such as Social Security, SNAP, Medicare, and Medicaid, safety issues such as words of protection, Technical difficulties.
Uh-huh.
One sec. Please hold. A moment.
Good. And is the microphone okay, too? Okay. All right, good. Hi, everyone. Good evening. Thank you for the introduction, Andrea. As Andrea said, my name is Maya, and I'm a senior housing attorney at Prairie State Legal Services, and I work in our Waukegan office, which covers all of Lake County. And I wanted to thank the Lake County Housing Authority for inviting Prairie State to do this presentation. We're doing this presentation now in April because April is actually National Fair Housing Month. It was actually April 11th. We're almost at April 11th, 2 days. April 11th of 1968 that the original Fair Housing Act was signed into law. So now every April we recognize it as National Fair Housing Month. So that's why I'm here to share some of your legal rights in housing. Okay, Andrea gave the disclaimer already. So yeah, when I say fair housing, I'm talking about housing discrimination. And housing discrimination is any practice that limits a person's housing choice based on a specific trait that is protected by law. So it's anything that limits someone's housing choice based on a specific trait that's protected by law. Not any trait, just traits that are protected by law. Let me give you some examples to start of what it could look like, and then we're going to actually go through what the actual protected groups are, the protected classes that are protected against housing discrimination. So here are some examples. I don't have to go through all of them, but here are some examples of what housing discrimination could look like. These are hypothetical quotes from landlords like, we only rent to English speakers. We won't let you build a ramp for your wheelchair. I prefer to rent to women. We don't allow support dogs unless it's just like an emotional support animal. We only allow seeing eye dogs. We don't accept vouchers. We don't offer mortgage loans in that part of town. The apartment has already been rented, and then we find out later that it actually hasn't already been rented. The landlord was lying about it, and when it was actually available. Those are examples of what discrimination could look like. There's a little cut off there. I don't know why, but anyways, I'll tell you just a little heading there. Sorry about that. The most recent data we have on trends on fair housing comes from the NAFA, the National Fair Housing Alliance, compiles data on the number of complaints that have been filed nationally, both with HUD, reporting to like state agencies, the DOJ, like complaints that come into fair housing agencies. And this was a report that came out in 2023 based on 2022 data. And based on their 2022 data, they gathered information of 33,007 fair housing complaints. And that's the highest number of complaints that have been recorded in a single year since NAPA has started gathering that data. And the complaints based on source of income and domestic violence have increased. Also, discrimination, complaints based on disability is also historically every year a lot of complaints are related to discrimination based on disability as well. Who can violate the fair housing laws? I'm sorry, I'm not sure why the top is cut off. It's funny, it looks cut off there, but not on the screen, but oh well. You can imagine what the top of the heading looks like. These are examples of housing providers who have to follow fair housing laws. These are examples of the types of people and organizations that are not allowed to discriminate in housing. And as you can see, it's basically anyone that works in the housing industry, right? Landlords, of course, and at Prairie State, we work a lot with clients who rent, so rent properties. So we have a lot of examples of discrimination that we hear about that are related to landlords, but it's not only landlords that have to follow the fair housing laws and that are not allowed to discriminate. Also, people that sell property, realtors, banks that give out mortgages, public housing authorities like Bullitt County Housing Authority, insurance companies that sell home insurance, employees of a housing provider, and even neighbors. Neighbors is a little bit nuanced, so I won't get into that one, but there's some case law to suggest that if a neighbor is discriminating against, if a tenant is discriminating against another tenant, if the person that's the victim of the discrimination reports it like to their landlord and the landlord doesn't do anything about it, even though that discrimination wasn't done by say a neighbor someone was routinely calling their neighbor like by a slur, by a racial slur, and then that tenant reported it to their landlord and the landlord didn't do anything about it. The landlord isn't the one that's making the racial slur, but because they didn't take any action, they might be liable for discrimination in that situation. All right. Oh, look, it looks all pretty again. All right. Here, I gave a lot of examples, but I didn't tell you yet what are these protected characteristics, or the legal term is protected classes. What are the protected classes that are protected against housing discrimination? At the federal level, I mentioned the Fair Housing Act, right? That's the federal law. So this is anywhere that you go in the U.S., housing providers, and I usually, even though as you saw on the previous slide, it's more than just landlords, I'm going to probably use the term landlords a lot just because, like I said, in my work, that's what I see a lot of. So if I say landlords, just remember in the back of your mind, it also includes like other housing providers too. Landlords and other housing providers are not allowed to discriminate based on someone's race, their skin color, religion, sex, nationality or national origin, familial status, and disability. For nationality, national origin, just as it sounds, the country that someone is from or that their family is from. Familial status means people that have children under 18 in their household. And disability, which we'll talk about a little bit more close to the end of the presentation, includes protections for both physical disabilities and mental disabilities. So landlords cannot discriminate against people based on their race, their color, their religion, their sex, their nationality, the fact that they have children under 18 or women who are pregnant, or based on their disability. That's the federal protection. And then in Illinois, we also have additional protections, and this is under the Illinois Human Rights Act. The Illinois Human Rights Act is our state law that protects us against, that explains what housing discrimination is at the state level. So obviously the federal law applies here, but then we also have protections in Illinois based on age, marital status, military status, order of protection status, pregnancy, sexual orientation, arrest record, source of income, immigration, and reproductive health. I'm going to talk about a couple of those in more detail, some of the newer ones. I have a couple slides on some of those newer ones. The ones that I don't have slides on that I'll just mention. Age discrimination. Sometimes I have people try to guess what's the protected age that landlords can't discriminate based on. So landlords cannot discriminate against people who are what age and older. Sometimes people guess 65 or maybe 18. Anyways, so it's actually 40 years old. And marital status means landlords can't treat people differently who are married versus single, like maybe a landlord that only rents to married couples, not to people that are unmarried. That would be discrimination based on marital status. Military status, order of protection protects people who are who have the order of protection or a restraining order of some kind against someone else. So a landlord cannot treat someone differently. Maybe they don't want to rent to someone that has an order of protection. Or someone gets an order of protection and they say, we don't want to, this is too much, there's too much, we don't want this in our property. They cannot refuse to rent to someone or try to evict someone because they have an order of protection. And then I'm going to talk about a couple more of these in a little detail here, a couple of the newer ones. Arrest record is one of the newer protections. As of 2020, it became part of the Illinois Human Rights Act that landlords couldn't discriminate based on someone's arrest record. This is more narrow than just criminal records. So landlords, I know I get this question a lot, can a landlord run a background check on and look at criminal records? They can. The protection in Illinois is more narrow than that. It only protects people who have arrests that didn't lead to convictions. So if a landlord decides, runs a background check, and they see on someone's criminal history, they had an arrest, but it was dismissed, or thrown out. Nothing ever happened, or maybe they were never even charged. Maybe they were just arrested, and there wasn't even. That cannot be held against someone at all. And it also protects convictions, juvenile records. So landlords can't discriminate against people who have any kind of juvenile records or records that have been expunged or sealed or impounded. Funny, I don't know how that happened again. Anyways, so another new protection we have in Illinois is source of income discrimination. That became the law 2 years ago, just over 2 years ago. In January of 2023, this new protection was added to the Human Rights Act called source of income. And this protection, this is the definition. You can see it in bold on this slide. This is how the Human Rights Act defines source of income. Source of income is the lawful manner by which an individual supports himself or herself and his or her dependents. So here's just some examples on this slide. What are different ways, think about it for yourself. What are ways that you might support yourself and other people in your household? Maybe employment, maybe a job, maybe from Social Security. Maybe you receive child support or retirement benefits. All these different unemployment benefits. These are all examples of different ways that people support themselves and their families. And then the first one on there, which is the one that I think impacts a lot of the clients potentially that we see, is housing choice vouchers. Housing choice vouchers, sometimes people refer to as Section 8 vouchers, it's a type of, that is a way that a lawful way that an individual supports themselves and their families with a voucher. So let me give you some examples of what source of income discrimination could look like. First, there's obvious discrimination. Obvious discrimination is like if this happened to you, you would easily probably be able to identify that this was discrimination. It's overt and intentional discrimination. Like an ad that says, we don't accept Section 8, or it's not Section 8 approved. You have a landlord that requires that you have a job to rent there. These are all examples of obvious and intentional discrimination. Here are more examples. Here on this slide are examples of source of income discrimination, still intentional discrimination, but these are examples of where landlords treat people differently, different treatment based on someone's source of income. Maybe it sometimes might not be easy, if someone is a victim of discrimination in one of these, they might not realize that they're actually being treated differently unless they know how the landlord treated somebody else. For example, a landlord that only runs background checks for certain people. A landlord decides that they're only going to run background checks on voucher holders that are applying, but not on others. That's a type of discrimination, right? They're treating them differently, or only running credit checks. of people with vouchers. Those are examples of difference in treatment. And then the third kind of discrimination that I wanted to share about source of income is this policies with a discriminatory impact. Most of the time, and all the examples really that I've been giving so far of discrimination are intentional discrimination, where a landlord, even if someone didn't know they were discriminated against, it was the landlord intended or the housing provider intended to discriminate. But there are cases where something could be illegal discrimination in violation of either the state or federal fair housing laws without the housing provider actually intending to discriminate. And it's called like a policy that has a disparate impact or discriminatory impact. So that means basically like a policy that maybe on its face seems neutral. It doesn't look like doesn't appear to be discriminating against a specific protected class, but it has a discriminatory effect. It has the effect of actually discriminating against people. And here's an example. Here's an example of one that we have seen. And there's been a lot of discussion about this. There have been cases with this type of source of income discrimination. Landlords have requirements, often have income requirements, and a common one is that a landlord requires that people to be eligible to rent somewhere, you have to make 3 times the rent. 3 times, show that your income is equal to at least 3 times the monthly rent. So say I'm renting an apartment and I'm trying to rent an apartment that's $1,500 a month. And the landlord says, show me that that your income is 3 times the monthly rent. That means that they're asking me to prove that I make at least $4,500 a month. If I had a voucher and I was making $4,500 a month, most likely I wouldn't be eligible to have a voucher in the first place. So this policy, this 3 times the rent, is a neutral policy, but you can see how, like, in practice, it has the effect of potentially excluding voucher holders because they would never be eligible in the first place. Now, I'm not saying that landlords can't have 3 times their rent policies. There are, there are ways to create a policy, a 3 times the rent policy that doesn't have a discriminatory impact, or that has less of a discriminatory impact. For example, if a landlord has the policy, show me that you make 3 times your portion of the rent. So like with a voucher, if someone's watching who doesn't know how the voucher program works, with a voucher, the housing authority will determine based on the rent, the tenant pays a portion of the rent and the housing authority pays a portion of the rent. The tenant typically the tenant portion is calculated based on how much their household income is, and it's typically like 30% they pay 30% of their income is calculated. I know it's so much math. And it's spinning too. That's how they calculate their portion of the rent. So if a policy said, show me that you make 3 times your portion of the rent, that would not be discriminatory, because by its nature, that housing voucher holders would qualify for that, would probably qualify for that kind of policy. And I didn't make this scenario up myself. This 3 times the rent guidance and this example of this policy with of a less impact comes from guidance from Cook County and City of Chicago, that have their human rights commissions, that they have had source of income as a protection at the local level for many years. So they've issued guidance that basically says to landlords, like, if you do this, it's discriminatory, and here's a way to have this policy with not without a discriminatory impact. And recently, I think in last year, 2024, IDHR, the Illinois Department of Human Rights, also issued some guidance on source of income discrimination. And if you go to their website, IDHR's website, you can find it on there. There's lots of a very thorough list of frequently asked questions about source of income discrimination, and they do give this as an example too, as a potential type of discrimination. Okay, reproductive health decisions is the newest protected class in Illinois. Again, I don't know why it's so strange with the heading there, but anyways, oh, whatever. We roll with it. Reproductive health decisions is the newest protection in Illinois. It was signed into law last year. It became effective only in January of this year, and it basically says that housing providers can't discriminate based on someone's reproductive health choices. Like a landlord cannot discriminate against someone who maybe has had an abortion or uses birth control, and these other examples too, has IVF treatment, things like that. So that is a brand new protection we have in Illinois as of this year. All right. I gave examples of these three categories actually, I'm going to just do a quick time check on my watch. Okay, cool. I want to make sure to give a little time if anyone has a question or anything. I don't know, we'll save that to the end. But here's some more examples of, remember I told you, when I was talking about source of income, I gave those like three different categories of discrimination: overt discrimination, covert or different treatment, and other violations like disparate impact, maybe if it's a neutral policy that has a discriminatory effect. So here's some more examples of this slide. I won't read every single one of them because it will take a while. But here's other examples of what, in these three categories, what discrimination could look like. For example, someone making a discriminatory statement. Just saying, we don't rent to families with children. Just that statement in and of itself is discrimination. Just by making that statement, it's discriminatory. Creating a hostile environment, retaliation, like taking action against someone based on their asserting their fair housing right, threatening someone, lying about the availability of housing. I think I gave that example at the very beginning. A landlord that maybe tells one person, housing is not, we don't have any apartments available. We've seen this, right? Like we've had this where we had an African-American client would, go seek housing and was told it wasn't available, and then a white tenant could be, go to the same place and told that the housing is available, or you can use that hypothetical, you could use that hypothetical with like any protected class. Refusing to sell or to rent to someone based on their protected class. And then, like I said, these are just other examples. The reasonable accommodations and modifications I'm going to get to in a second. Okay. Good. Okay. Moving on, I want to kind of finish up, I think, the last few slides with rights for people with disabilities. So I always acknowledge the shift here from the first part of the presentation, because the first part of the presentation for fair housing, I usually focus on how everybody has to be treated the same, right? That housing providers have to treat everybody the same. But then now we're looking at things a little bit differently for the rest of the presentation, because now we're looking at rights, only that specific rights that that people with disabilities have, that other protected classes don't have. These are specific fair housing rights for people with disabilities, with both physical and mental disabilities. And those are the rights to make reasonable accommodations and reasonable modifications. First, as I said, just to reiterate, a disability is defined as a physical or mental. So it could be basically anything you can think of, a physical or mental impairment that substantially limits a major life activity. That's how it's defined. And so people with disabilities have these rights. The first right, one of these rights, as I mentioned, is to make a reasonable accommodation. A reasonable accommodation means that a person with a disability has the right to request changes or exceptions to certain rules or policies if it will allow them to more fully enjoy the use of their property. So here are just a couple pictures to illustrate some examples of what a reasonable accommodation could look like. I just pulled some common ones, but the possibilities are endless. But here are some common ones that I've seen. One of them is that picture with that cute little dog is to illustrate the idea of an emotional support animal. So say a landlord has a rule, a policy that they do not allow pets, but the applicant or the tenant has an emotional support animal, or a service animal. So then they have the right to make a reasonable accommodation, requesting an exception to that no pets policy, because their animal is not a pet, it's a support animal or a service animal. So that's an example of an accommodation. That second picture there of helping someone down the stairs, I use that picture to kind of talk about two different common examples of accommodations. One of them is when somebody lives in an apartment building, maybe that doesn't have an elevator, and say they live on a top floor apartment, but they develop or they have some kind of mobility impairment that makes it really difficult for them to climb the stairs. They could ask as an accommodation as a change that they be transferred if there is a first floor unit available to a lower floor unit, because then they won't have to use the stairs. That's related to their disability. The other example that this could illustrate here is like adding a caregiver to someone's household or something like that, because they need like a live-in caregiver, adding them to the lease or something like that. And then the last example is of a reserved parking space. So say there was an apartment building that didn't have any reserved spots. You just park like wherever, first come, first serve, but then it's difficult for somebody to walk long distances. It's difficult for somebody to walk distances into the to park somewhere. So to walk a long distance for parking, so they can request a reserved spot as an accommodation so that they can then have a guaranteed spot close to the entrance to the building. So that's another example of an accommodation. Those are examples. And one thing I want to say about the pet that I didn't say, another thing with emotional support animals and service animals is that some landlords will allow pets, but they charge like a pet fee, like a pet deposit fee or a monthly pet fee. That's something else that if somebody has an emotional support animal or a service animal, they could ask for an exception to that policy, that they shouldn't have to be charged a pet fee or a monthly pet fee because, like I said, it's an emotional support animal. And then here's just I'm going to kind of speed through this, but here's some examples of, this is actually going through the, like an analysis of what someone has to do to get a reasonable accommodation or modification. Okay, actually I'm going to skip this slide and go to the next one and then come back to it because it makes more sense to do it this way. Okay, another thing that people with disabilities have as a right is to request reasonable modifications. A modification means like to ask for a physical change to their property. And again, it has to be somehow related to their disability. And then you can see there's like pictures on here of physical changes to the property, like that picture all the way on the left is an accessible bathroom. It has grab bars. There's a walk-in shower. There's like bars by the toilet. It's a floating vanity. That's an example of physical changes to the property to make it accessible, widening a doorway to allow that's the second picture there, to allow a wheelchair to go through it, building a ramp at a property for someone with a wheelchair, and then there's a fire alarm there that lights up for someone who maybe has hearing impairment that can't, which is, I think most fire alarms have this now routinely anyways, but, asking if, say there was a fire alarm in your unit or something, and you it didn't have that, you could ask for that as a physical change to the property, as a modification. Okay. So, going back to this slide again, here's like the analysis I was talking about. So, to be granted an accommodation, remember I said accommodation means like you have the right to ask for an exception to a rule or a policy, or a modification. Of course, first the housing provider has to know about the disability, has to be aware that the tenant has a disability. The accommodation or modification has to be necessary to help with the effects of the disability. I said that before too, right? Like, there has to be what you're asking for from the landlord has to, of course, be somehow related to the disability, lessen the effects of the disability. It has to be reasonable. Missed one. Tenant has to actually request it. A landlord doesn't have to guess that a tenant needs an accommodation or modification. Tenant has to make the request for some kind of change related to a disability. And then the only times, these are the only times that a landlord can deny an accommodation or modification is if they can show that it creates some kind of burden, an administrative or financial burden, like maybe it costs too much, or it requires them to fundamentally alter the nature of their services. Maybe it's asking them to do something that is not at all within the realm of what they as a landlord do. And then also there can't be a direct threat. So whatever the person is asking for, if there's some kind of like a health or safety issue, then a landlord might be able to deny the accommodation. But the key is, even in that case, they have to show that there's no like alternative accommodations that could alleviate the threat. So let me just give you an example of that with the emotional support animals. Say I have an emotional support animal that became really aggressive and attacked another tenant at the property. Okay, well, that is danger. And attacked and bit another tenant, right? So that could be a direct threat. The landlord might be able to say, in that case, like, we aren't going to allow your emotional support animal here because it's a safety issue for our other tenants. But then I would say in that case, there should be a discussion between the parties. Is there anything that the tenant can do to maybe, to alleviate that direct threat? Maybe they can agree to, this is all hypothetical, like every one of these situations is like super fact specific, but maybe they could offer to take the dog to training, make sure that the dog is very restrained, not in public parts of the building, things like that. So that's kind of the analysis of accommodations and modifications. And then going back to the physical changes to the property, the one more thing I wanted to mention about this is, I guess the thing I'll tell you the answer to the question most people have is who pays for these changes. So unfortunately, they can be really expensive, right? Like making a bathroom accessible, building a ramp. Most of the time it's on the tenant to pay. The landlord has, in any kind of private housing with a landlord, including a landlord that accepts a voucher, the landlord has to allow the modification, the change to the property, like if someone's asking for this, but they don't have to pay for it. In housing that receives federal funding, federally subsidized housing, or public housing owned by one of the housing authorities, in those apartments or complexes, it's on the landlord has to pay for the physical change. But in other housing, in private housing, they only have to allow it, but they don't have to pay for it. A landlord can require that somebody that wants a modification, a physical change, gets permission before making the change, that the work will be done professionally. They might be able to require that the unit be restored to its original condition before they move out, if what they did would affect the next tenant's use. So like, if somebody made a modification where they lowered the cabinets in their kitchen so that they could reach the cabinets, that might be an example where a landlord says, after you move out, you have to put the cabinets back up to their original height, because that could affect the next tenant who, if they didn't need lower cabinets, that could affect their usage of it. But like say somebody widened a doorway by a few inches to get a wheelchair through, that would not really, right, exactly, that would not be, that would probably not be reasonable to like ask somebody to make it more narrow again after they move out, because adding a few inches to a doorway wouldn't affect the next tenant's usage. Exactly. And then I mentioned a thing about paying, who pays for it. The key with all reasonable accommodations and modifications is this concept of interactive process, is that when somebody makes a request to a landlord or housing provider for an accommodation or a modification, the landlord is really required to have an ongoing dialogue with the person making the request to see if they can come to some kind of an agreement that'll help the person with the disability, even if so it's not like an open and shut case. So if I go to a landlord and I ask for reserved, I'll give the parking space example. I ask for a reserved parking space. I want a space as close as possible to the entrance to the building. And the landlord, and I don't give any explanation as to why I need it, or I don't give a doctor's note to support to explain why I need it. The landlord can't just say, "Oh, no, sorry, denied." They are required to like follow up and ask for more information. Hey, why do you need it? Can you give us proof? Can you give us a letter of support from your doctor? So even if they don't have all the information at first, or maybe they do have all the information, but they can't accommodate the person, like what the person's asking to do, they can't actually do. For example, like I gave an example of somebody's on a second floor unit, and there's no elevator in the building, and they want to move down to the first floor unit because because of their disability, it's like really hard to climb the stairs. What if they make that request and then there is no first floor unit available? Does the landlord then just say, "Sorry, your accommodation is denied, we don't have anything available"? No, again, this is an interactive dialogue. It's on the landlord to have a ongoing conversation with the person making the request to see, is there something else I can do to help accommodate this person? So some examples, what are some things that someone could do if they can't actually like transfer you? Maybe they could offer to put the person on a wait list and put them at the top of the wait list. So the next first floor unit that's available, you get it. You're the top of the list. Maybe they offer, okay, we don't have anything available, but if you can't climb the stairs, we will let you break your lease, and you find somewhere else that is a first floor unit somewhere else. We'll let you break your lease early and not penalize you for it, so that you can go to this first floor unit at a first floor building somewhere else. So like I said, it's just an ongoing dialogue between the two sides to see if they can get the person with a disability what they need, and it requires a lot of follow-up negotiation and dialogue, like I said. So last thing I wanted to say is, like, what do you do if you feel like you've been a victim of housing discrimination? What are your rights? Where can you go? Well, come and talk to us, as Andrea said at the beginning, and I'll have a slide about this at the end too. You can always come and talk to us, and as long as you're eligible for our services, you'd have to come and apply, and if you're eligible for our services, we could talk to you about your potential discrimination, give advice, possibly represent. But where could you go? Where can you go to file a complaint if you feel like you've been a victim of discrimination? You can file a complaint with the Illinois Department of Human Rights. That's one, or IDHR, mentioned it, or with HUD, Department of Housing and Urban Development. So HUD is federal agency. IDHR is the state agency. They both enforce fair housing laws, and they both, you can file a fair housing complaint for free. You can go to either of their websites and find information on how to file a complaint for free. you have the one thing that I would like to remind you of is that even though it's free, you are required by law, the statute of limitations is only 1 year, meaning that if you believe you've been a victim of housing discrimination, you have to file, if you're filing a complaint with one of these agencies, it has to be done within 1 year of when the most recent date of discrimination happened. All right, and let's see here. Oh, never mind. I missed another slide. I forgot to add another little icon here for the second place you can file if you don't file with IDHR or with HUD. Of course, you can also file a complaint in court, in either state court, circuit court, or federal court. That has advantages and disadvantages. One of the maybe disadvantages of filing in court is that there are filing fees for serving other parties. Sometimes you can get those fees waived if you can petition the court for a fee waiver, but that is a potential cost. Also, but one of the benefits to filing a fair housing complaint in court, as opposed to with one of these agencies, is that the statute of limitations is longer. So instead of having 1 year from the date of discrimination to file, in court you have 2 years from the last date of discrimination to file. And then there's also remedies that you can get at the these are different remedies. In court, you can ask for punitive damages, which is something you can't ask for in one of those in the state or federal agencies. But here are examples of, like, in any case, regardless of where you file it, what are some things you can ask for in your complaint? What are you trying to get? Like, obviously the housing. So if someone was denied housing because of the fact that they were women and they were denied housing because of their gender or something, maybe one thing that they are asking for in the complaint is that they be allowed to get into that housing, right? But there's also, or a policy change, maybe a landlord, here's an example, we were talking earlier about source of income discrimination, right? If a landlord has a policy that they don't accept vouchers and someone files a complaint against the landlord for source of income discrimination, one thing that they might be asking for in their complaint is change your policy. Now I want proof that you're changing your policy so that people going forward, you will accept vouchers from applicants. There's also monetary damages, like people can ask for damages, asking for emotional distress damages, or like damages, money for like pain and suffering, is really common in fair housing cases because there is a lot of, they are very, it can cause a lot of pain and suffering to experience discrimination in all its forms. So that's a really common thing that we ask for as well. And then there's some other examples on there too, like attorney's fees and civil penalties. If it's like at one of the agencies, it's a state or federal agency, they can ask for like civil penalties as well, to vindicate, for the state. Okay, that's all I have. I have some hypotheticals we could go through, but but before I do that, we don't have to do that either. I wanted to know if like anyone had any questions. Were there any questions like on Facebook or you guys in person? Yeah, hi, yeah. Mm-hmm. Yeah. Mm-hmm. Mm.
I have an emotional support dog. So when I came into the complex, I didn't have the emotional dog yet.
You didn't? Okay.
Yeah, I had to go through it. And so then when I did get it, and I got the letter and everything, they accepted it because they did not allow pit bull breeds in there.
Okay.
But because she was my emotional support dog, they said as long as she wasn't like vicious.
Yeah. Oh, good. Okay.
They accepted it because in their policy they banned pit bulls, so then they had to change the policy.
Oh, okay. Okay.
So now what the discrimination came in is when I got my medical marijuana card,
Mm-hmm.
and I guess one of the tenants in there doesn't like it. Like I wouldn't even, they said, oh, even if you have a medical marijuana card, you can't smoke in the building. We don't want anything on our community because it's a community housing community. So they said they didn't want it, and they were like, oh, and I'm like, okay, well, I'll go to my car because again, I understand people don't want to smell. I was like, but I have a medical reason because I didn't want to be on benzos and
Yeah.
so I said I would rather do that. And I decided that. So then it's like they're like getting attendance. They was having people bring their dogs to try to see if my dog was vicious. One of the tennis dogs attacked my dog, and it was like a little Shih Tzu, and my dog, and my dog just ran away from that dog. She's like an emotional support dog. Like she's with me. I was training her and doing all that stuff. And so with the medical marijuana, they put this last one. They did send things saying that the neighbor next door. She said, "Oh, I can smell it." Like she would open her door after I would come into the house and like smell it, because I'm like, if you smoke a cigarette or you smoke marijuana, it's gonna be on your clothes. And she would go to the office and report that I was smoking in my apartment, and then they just believed what she said and put a notice on my door saying that some people were making a report that they smelled marijuana coming from my apartment complex, and that it's not allowed, and then they'll give me if they smell it again, they'll give a eviction notice. And I said, excuse me? I was like, you're going off. If I smoke outside and come in, it's going to be on my clothes. And she's opening her door, harassing me.
So I can't talk about a specific situation here, so I can't give you like legal advice about your specific situation without you being a client. I can just talk about things in general. But I would say if you are, I'll give you information in a sec about like how, I don't want there, we're good. If this is happening now and you want to come and talk to us, have you talked to Prairie State before or no? Okay, so I'll give you information. We have flyers here too, or I'll have a slide here too. So it might be, so that's an example of a potential reasonable accommodation, right? With a medical marijuana card, possibly. I will say, like I said, I can't give you talk specifically about your case. I will say like that the rule in just like generally speaking, I don't know exactly what kind of housing you're in, but like with, public housing that receives, or subsidized housing that receives federal funds, they have rules in there, like where you can't smoke marijuana in the property, and in that situation, like in the federal funded housing, like that law would override whatever the state law is about marijuana in those properties. But otherwise, I would say come and talk to our office. But the emotional support animal, you brought up a good example of something I didn't mention, which was the thing about like breeds, right? That landlords sometimes have breed restrictions. And a really common one is like no pit bulls, because a lot of landlords believe that like pit bulls are, even those, I've met some very adorable pit bulls. I know. Oh, you have a pit bull too? Okay, there's some pit bull lovers in here. Okay. I have a beagle, but, what? Almost, yeah. She's pretty cute. But anyways, so a landlord that had a rule like that they don't allow certain breeds, or sometimes landlords have rules, weight limits for dogs too. Like they only accept dogs 25 pounds and under or something. So those are both examples of things where if you did have a breed that was a pit bull breed, like in your case, or or the dog was larger than whatever the weight limit was, but it was an emotional support animal or service animal, that would be an example of a reasonable accommodation. Somebody could make an exception to that policy for the breed. Now, obviously, if the landlord could show that actual, because like landlords can't deny a dog based on like a stereotype about it. But if they knew, like I mentioned this earlier, like if they knew that the dog was dangerous, like that specific dog was dangerous, yes, like they attacked someone or they bit someone, that'd be different. But I'm going to give you some information in a minute about how you can contact us. Were there any Facebook questions? Oh, two, okay.
So the question has to do with criminal records, and the question has to do with eviction.
Oh.
So if the eviction, a
past eviction fell under qualifications of
Oh, like if someone oh, good, okay. So if someone has an eviction on their record, can a landlord, is that a type of record that landlords cannot consider? No. That is not a protection. Landlords are allowed to consider someone's past eviction record. That is not part of one of the protected classes. So yeah, landlords can. Now there are ways to possibly seal those eviction records, but that would be something that if you do have some kind of, if you are in court or you have a pending eviction and you want to talk to us. When I say seal, I mean where it's sealed so that like it's not part of the public record, that future landlords wouldn't be able to find it in a background check. So, but a judge would have to grant that request and or an agreement with the other side a lot of the times, but it has to be approved by the judge. But anyways, but no, in general, landlords are allowed to, yes, not in general. Landlords are always allowed to look at past eviction history. That is not protected.
the other one was about
Okay.
how to prove it, and then how to, if it was how to prove it, and then how to prove it, I think.
Okay, harassment by landlords. So I guess the first thing I would say is, like I always say, like a lot of people have, unfortunately, you might have a conflict with your landlord. Landlords might harass you a landlord might harass you as a tenant. It doesn't always mean that it's illegal discrimination. You have to be able to prove that the landlord's harassment, in this example, was because of someone's protected class. So like you would have to show, so if a landlord was harassing me because I have young children, that would be different than a landlord harassing me because they don't like my outfits or something. They don't like, like there can be lots of ways, or they don't like me because they just don't like me. They don't like what I do for work. I don't know anything. So harassment, you have to be able to show that the harassment was because of you being in one of those protected groups. What was the second part of the question? I forgot, sir. Whoa, how's it proven? It's like the $1 million question. It really depends. I'm going to give the lawyerly answer of like, it depends on the situation, how you prove it. Sometimes it's hard. Sometimes it's hard to prove. Yeah, why is the landlord treating you differently because of a protection? Oh, great. How would you? Okay, so how would you? Well, there's different ways. So like, say we knew that the voucher holder example. How do we? Right. How do we know if say someone with a voucher went to a landlord and then the landlord said they didn't say we don't accept vouchers. They just said we don't have anything available. And then like the next day, someone without a voucher comes and asks, and then the landlord says, oh, we do have something available. Right. How would the person with the voucher who was turned away yesterday ever know that the landlord was actually lying to them? Yeah, it's really hard to prove. I will give you one example of how we could prove it though. They would have to really, there would be two ways. One would be if they knew, if they could provide proof of what the landlord did, like a witness or someone of what happened later where someone was treated differently from them. Another thing we can do at Prairie State to help with that is we have this really cool program. We have a fair housing testing program where we have volunteer testers. They're trained as like undercover kind of like secret shoppers. Where we have people that are specifically trained and they pose as renters and they go to a landlord wherever we assign them and say pretend that they're trying to rent from there, and then they see how they're treated by the landlord. So like, say we weren't sure if the landlord was really refusing to rent to voucher holders, we could send a tester who has a voucher and a tester without a voucher, so kind of like simulating what happened in the real situation, and then see how those people are, how they're treated, and then we have evidence, right? Because we have these reports from the person with and without the voucher, and then if we ever filed a complaint, like on behalf of a client, like we can use that testing evidence possibly as evidence in the case. So that's one example of a way. So I guess I would say, like, don't be, if you really feel like strongly that you have been discriminated against but you don't have proof, don't be, there are possible maybe ways that we can investigate it. So don't feel like you can't come and at least talk to us if you don't feel like your proof is strong enough. At least we can maybe talk through about what you would need to show to prove it. Yeah.
Can a landlord make you move based on like a safety hazard? They pose that your house is a safety hazard.
Oh, interesting. No, yeah.
They couldn't accommodate you, but you didn't want to move. You were in your apartment, fire, you didn't have.
Oh, that's such, no, I don't think they could, that's such a good question. I've done this presentation so many times. I have never gotten that question. That is such a good question. So interesting, right. So I'll just, right, like if someone has a disability that a landlord might consider like a safety risk, like maybe an oxygen tank, you said, maybe, or if they can't get down the fire escape or something, they're worried about that with their mobility. Can they say no? No, I would say they cannot. A landlord cannot do that because that it's not up to the landlord to decide it's not up to the landlord to make that call of like what the tenant can do. So no, I don't think a landlord can do that. That's a really interesting question. No, probably not. Probably not. Like more rental insurance if they think that they're more of a danger. I don't think so, because that's treating two people differently, like based on some, so I don't think they could. It's similar to like, I've had a similar question with like people that have the emotional support animals, and I've like, sometimes I get this question, like, can the landlord require that you have like extra insurance for, like if the dog, a dog would attack someone or something, and a landlord can't require that someone with a disability have to like incur any kind of like expenses for these for getting an accommodation or take these extra steps like that. So these are very thoughtful questions. Oh, how to prove that an animal is an emotional support animal or service animal. Okay, I love this question. What? You get it a lot. People that are asking, are you saying like people that are living in housing, LCHA housing? Oh, interesting. Oh, landlords that have voucher holders that ask if they should allow someone. If they're allowed to ask for proof of the disability. Oh, so interesting. Okay, yeah, okay. Good question. So to start out, so you said what kind of proof can a landlord ask for? So like with any accommodation or modification, they can ask for proof of, or verification, I should say, of someone's disability if it's not obvious. I use the term obvious because that's just the term that like is in like the HUD guidance. So like if it was something, if the landlord could identify the disability right away, like the most easiest example I can give is like someone in a wheelchair that needs some kind of accommodation, like they should not have to prove that they are disabled, because the landlord would be able to, to identify that easily without needing verification. But in most cases, with accommodations and modifications, the landlord is required to ask for some kind of a verification, to show like two things basically. One, that the person has a disability. The verification, the person asking does not have to necessarily disclose their diagnosis. Some tenants are okay with disclosing it, but they have to at least show like how their disability affects a major life activity, like sleeping or walking or concentrating or something like that. So they can ask for verification from that the person is disabled, and then they're allowed to ask for verification of like an explanation of how what they're asking for is connected to their disability. So like with the animal example, they could ask for some kind of verification letter that explains why they need an emotional support animal, how that like alleviates the symptoms of their disability, like they have anxiety, my patient has anxiety, it keeps them calm, the animal keeps calm, or things like that. Does it have to be a doctor? That's another question I get a lot, like who writes the verification letter? Not necessarily. For emotional support animals and service animals specifically, there was like guidance from HUD that came out in 2020 that talked about the verification and talked about like, they don't say it has to be from a healthcare provider, but the examples that they give are with healthcare providers. So, that's a way, getting some kind of letter from like a doctor or a psychologist or a psychiatrist, while it's not required, I think it probably, if you can get it, probably it will raise the least number of follow-up questions from a landlord, but you're not required to get it from one of those sources. Guidance from HUD on reasonable accommodations says that it can be someone else that's familiar with the disability. So like, a social worker, a caseworker, it could be your caseworker, like maybe the caseworker at the house, a caseworker, maybe a pastor. I think that was one example in there too. But like I said, I think it's, if you can get something from someone, a healthcare provider, like it doesn't have to be a doctor, psychologist, but a PA or even a nurse or anyone that can verify and talk a little bit about, like I said, can make the connection between why you need the animal and the disability. Okay, how soon do they have to meet the request? So that's like a really good question for accommodations, like in general. How fast does a landlord need to respond to a request for an accommodation or modification? And I'm going to give you the same lawyerly answer. It depends. It really is fact specific, because there's nothing in the law that says like you have to respond within this number of days. I think like there are some agencies like LCHA might have a policy on this. I'm not sure. Sometimes housing authorities or landlords might have a policy, an internal policy that they follow, like we will respond to your request within 5 business days or something. I just made that number up. But there's nothing in the law that says an exact time, so I think it really depends on what you're asking for, maybe how urgent it is. But like I said, it's really fact specific. But there is case law out there and guidance that if a landlord takes too long, and again, I don't know what too long is, but at some point when a landlord doesn't grant an accommodation, even though they haven't said no, it's basically like you could say, they said no. You could take that to, if you're alleging a case where they improperly denied an accommodation and they say, well, I didn't deny it, I just never responded to it. At some point, a delay is the same as a denial. But there is no set amount of time. But I mean, yeah, it shouldn't be, I would say if somebody's making an accommodation request or request for a modification and and it's been a while, and I encourage follow-up, right? So if it's been a few months and you haven't gotten a response, I wouldn't wait that long. Like if it was me, I would, follow up. And I think it's really important to, even though accommodation requests do not have to be in writing, there's nothing in the law that says that the requests have to be in writing. I always encourage people, put your requests in writing. that's really for anything you ask for from your landlord is probably a good policy, like to put your request in writing, because then you have proof of it, right? Instead of just a verbal request, you have proof that you made the request. So I would say put it in writing. If you are a client of the housing authority, you're making an accommodation request here, like some landlords and housing authorities have like special forms that they ask you to fill out, like a reasonable accommodation, like a form explaining what you need. That's fine. That can help them kind of go through the process of figuring out what the person is asking for. But guidance from HUD also says that housing providers can't require that you make the request like with a specific form. So like say I made an accommodation request for an emotional support animal, but I haven't filled out the form yet. Like I still they should still start communicating with me about the request and working with it. They being the landlord or whoever it is. So yeah, great. That's all the online questions. Do you guys have any more questions? No. I don't know if you want to finish early or use a scenario, do a couple scenarios. What do you want to do? Let's do a scenario. Okay. Oh, here's a good one. This is actually a good one. I like this one. Okay. Hypothetical. I'm going to call on you that are here. Well, no, I'm not going to call on you if you would like to answer. I don't want to put pressure on anybody. Okay, so say Jack has a young son, and he's told by his housing provider that he can't rent a unit on the second floor of the apartment complex because they keep families with children on the first floor. They have a policy. Oh, we put families on the first floor because there could be noise. The second floor.
Yes.
What do you think? Is that discrimination? Yeah, why? Right. Exactly. That is, yep, yes. I'm so glad sorry. I am so glad you picked up on it. Oh, I was playing with my microphone, sorry. Yes, it is. It's like segregating them totally. Right, and it's discriminating against people with kids, and that's the protected class, families with kids. So yes, the landlord would not be able to do that. That would be discrimination. Okay. Jane, here's another example. Jane, a black woman, is told at a housing provider's leasing office that there are we kind of talked about something like this, that there are no available units, even though several were listed as available online. She later learns that a white coworker contacted the housing provider right after she did and was told that there were units available. It is discrimination, right? So even though the housing provider in that case didn't say to Jane, we don't rent to, didn't say we're not going to rent to you because of your race. Like they lied about the availability of housing to her. So yes, that is discrimination too. Okay. Oh, what a cute. It's not a beagle or a pit bull, but we'll go with it. So John has anxiety and has an emotional support dog to help him stay calm in stressful situations. He provided his new landlord with a note from his doctor explaining that he needs an animal. The landlord says that, hope you remember the answer to this one, we talked about it, that Jack will need to pay a pet deposit to have the animal stay in his apartment. Can the landlord require that nope, you're right. Nope, they can't, right? Because they can't charge a pet deposit fee for an emotional support animal. For a regular pet, for a pet they could, but not for an emotional support animal, right? Good job. Okay, I think this might be the last one. We haven't really talked about this type at all, but okay, they say there's a receptionist at Sally's apartment complex makes sexual comments about her body every time she visits the office. It is sexual harassment, and that's something we didn't really spend any time talking about, but so I'm so glad that came up at the end as an example. It is sexual harassment, you're right. And sexual harassment is actually a type of discrimination. So one of the protected classes at the federal level is sex or gender. And under that, sexual harassment falls under that, is a type of discrimination. So if someone makes sexual comments about someone or unwanted sexual advances, things like that, either harassment or creates some kind of hostile environment, that is discrimination. I know you don't automatically think of sexual harassment as a type of discrimination. could also possibly be a crime depending on what they do. But yes, it is, it's sexual harassment is a type, by a housing provider is a type of, yep, a type of discrimination. Okay, so I'm going to finish by just giving you this information again. And we have, for those of you here, we have some flyers with this information too. If you're looking online, you can write this down. But this is the Prairie State's address, our Waukegan office address. We cover all of Lake County, and you can call our office, and on certain mornings, I think Monday through Thursday, there's we have that. We can give you paperwork. Yeah, I'll give it to you in paper. A colorful piece of. No, you're good. No. I'm sorry. You all said this, but I'll actually give you a nicer. We have nicer flyers for that. So, yes, we also have, but we have walk-ins on Wednesdays where you can come as long. It says 9 to 9:30, but you can actually get there as early as 8:30. Make sure you check in by 9:30, and as long as you are qualified for our services. And it's like a legal issue that we can at minimum give advice on, like you'll be able to talk to an attorney that day without an appointment. But if you call, we also have phone counselors, so if you call and kind of it'll guide you through your legal issue. We also have like opportunities where you can talk to an attorney on the phone for some advice. And that is my presentation. Let's see. 7:25. Okay, I'll take it. All right, well, thank you. I'll say a little closing there, and for those watching on Facebook too, thank you so much. Thank you, Liz, Lake County Housing Authority, as always, for inviting us. It's really appreciate you inviting Prairie State to do the fair housing presentations for you, and and in honor of National Fair Housing Month. And hope everybody has a great evening. Thank you.